I appear today at the Heidelberg Magistrates Court for family violence related charges. We're talking about some very high level charges here, including strangulation, causing injury, and certainly in the presence of the children very much aggravates the family violence situation. Now, the result, with the matter listed at a contested hearing, the police made an application for a full withdrawal of the matter after a successful negotiation prior to the hearing. How did I achieve this result? Well, one thing that people need to understand is that family violence matters very much and almost always rely on the position of the complainant. The complainant is the person who made the complaint. It is what we otherwise know as the victim once the charges have been proven. And the victim is usually either the wife or the partner or the significant other of the person that is accused, the family violence offender. In this case, the complainant was not supportive of the police case. As is the case with many family violence incidents, the police will capitalize on an intense and highly volatile situation at the very start of a matter, usually within the first couple of hours. Thus being the nature of family violence matters, police respond usually very quickly and usually obtain statements in that moment of heightened volatility. As is the case with many family violence matters, the complainant, after that heightened state of volatility does die down, usually reneges on the statement, changes their mind, and decides not to support the police case. This was that kind of matter. The complainant sought to not pursue the charges against the accused for whatever reason, and the reasons usually are unique to her and the circumstances of her relationship. One cannot say that the accused got away with committing a crime because we don't know if what the complainant had originally said was actually true. The only people that know what was true are the complainant and the accused. The police do not. The police responded to a situation where a report was made after the fact. I can say very confidently, and I have no doubts about the fact that my client could have fought a successful defense on the basis that much of the evidence in the brief did not corroborate what the complainant was saying. Once the complainant had made her position very clear, the prosecution realized that they didn't have much of a case, no evidence to stand on, and promptly withdrew the matter well in advance of the contested hearing. My reflections on this are that despite the state of family violence in this country, and despite the fact that there are many social and political pressures to try and prosecute family violence offenders, I am grateful for the fact that my industry still relies on an evidential basis to prove charges and to prosecute accused. At the end of the day, whether it's a family violence situation, and no matter how bad the allegations might be, if there is little evidence to prove the charges beyond a reasonable doubt, the prosecution do not have a case. And if you are dealing with a sensible prosecutor, will withdraw the matter